A home can be owned in different ways. Tell us a little bit about that.
Well, if it's a husband and wife buying a home, traditionally, if the deed says husband and wife, it's a legal term. It's called tenancy by the entirety, which means they both have a 100% interest in the house, and they would both have to agree to any sale. But for estate planning reasons, they may want to hold title by what's called tenants in common, which means that they each own one half of the house. The deed actually will say husband one half interest and wife one half interest, and then each of them can, in their separate wills, could convey their interest in the house. So it's a way of like equalizing their estates if they want not all the money in the one spouse to equalize it.
What about elder law? I'm running into some things right now, and there's people, they may have bought the house 40 years ago. It's been paid for 20 years, and they really don't know. Do you deal with a lot of seniors?
Yes, I definitely deal with a lot of seniors, and elder law covers a huge area, but as far as the real estate end of it goes, quite often I deal with putting the house into trust for a senior. And there's a couple different reasons. One reason would be to avoid probate. And I'm sure a lot of people in your audience have heard about how, particularly if they know people in Florida, that everyone has to have a trust and have their house in a trust. Yeah. Well, up here that's really not true, that if you have an immediate family, you can have your assets, including your house, go through probate. And it's not a really complicated process. It really doesn't take that long, and it's not that costly. But where it would be a good idea to put your home into a trust and avoid probate would be where you have no immediate family. Because the surrogates court has a lot of special rules that if you don't have anyone that's at least a first cousin or closer in relationship, then they're going to require a company, usually a genealogical search company, to find every single relative at the same level of generations away from the person that died. And that's a very time-consuming, very expensive process. Because think about it, you probably have relatives through an uncle or an aunt, a very distant cousin that you don't even perhaps know the name of, let alone have had a relationship with.
Wow.
So in those situations, I have done trusts, and the trust will appoint someone as trustee. And when the person dies, that trustee can then distribute all the assets, and you never have to go to a surrogates court. The trustee makes all the distributions and settles the estate. So it's very efficient.